Good evening. This is Judge Braxton from the Third Circuit Court, Lincoln Hall of Justice, the Juvenile Division. I wanted to come to you today just to provide some updates as we are experiencing the COVID-19 pandemic. The court is currently on a mandatory furlough until April 13th of 2020, and quite frankly, that date is subject to change. In these changing times, we're trying to look at different ways of having our court hearings, and one of those ways is access through Zoom conferencing and airing those for the public through YouTube. With that being said, I decided maybe this is a good time for me to try to figure out how to use all of this technology that I only use for fun, but now we have to use for more serious things like our court hearings. So first and foremost, I hope everyone is staying safe and staying at home, and on the occasions that you are needed to go outside of the home, that you are practicing social distancing. If your family members are in a position where they have contracted the coronavirus, I am sending my well wishes to you and your family in these trying times. I'm also asking that you be extremely patient with the court. We are the busiest court in the state of Michigan. This is unprecedented, and there were no policies in place to deal with having a full closure of the court. So we are creating policies day by day, and those policies are changing as we realize that they don't necessarily work as well as we thought they would. So you do have to be patient with the court. Our deputy court administrator is doing an excellent job in trying to get all these policies in place so we can handle our cases as best we can. As I previously said on my Facebook page, we are going to go with YouTube and the Zoom conferencing, and they are practicing that with the criminal division first. And once they work out all the kinks, they're going to try to bring it over to juvenile. Understand that our hearings are very different than the criminal hearings. The criminal hearings have the two parties, the state and the defendant. And in our hearings, we have the state, we have the case managers if it's a delinquency case, we have the department if it is an abuse neglect case, we have parents, we have the youth, several attorneys. So we have a lot of different working parts, and we have to pull more people together than the other divisions. So it's going to take us just a little bit longer to get it done. But rest assured, we're not just sitting at home twiddling our thumbs. We are working diligently to get this up and running. So I did want to discuss a couple of policies that we have in place right now. Hopefully I have provided this information on my Facebook page and you were able to see it. But if you weren't, I'm going to give you this overview. As the policies change, instead of me posting the actual policies on Facebook, I'm going to be practicing my technology and using this as a network to share this information with you. So this policy is going to be a little bit longer this time, but moving forward, I will only be sharing the policies as they come down to me. I share them as quickly as I can. I cannot share them until they become public. Sometimes we hear about it and we have to make sure it works, and it has to go through the proper protocol before it's approved. But as soon as it becomes public, I will share that information with you. One of the biggest questions, or the most important question I'm getting so far, is what about our youth that are in the residential facilities right now? And we do have a policy in place. Thank you again to DCA Richard Smart. And that policy is as follows. The defense attorney has to make a request for that youth to be de-escalated. That request has to go to the prosecutor's office. Before they make that request, they have to obtain certain information from the assigned CMO, case management organization, for that particular youth. That CMO will provide information to them, hopefully a report and some additional information that should be provided to the defense attorney. Once that defense attorney has that information, the defense attorney needs to contact the prosecutor's office and submit that request. Once the prosecutor's office has received that request, they can either agree with the request for de-escalation, as you would in a court hearing, or you could in fact disagree. Once that information is obtained by the prosecutor's office, they are supposed to send that information to the jurist of record, at which point in time, if the jurist of record agrees, then we can generate an order for de-escalation, which will be available in Odyssey. If all parties cannot agree, we would then have to schedule a hearing via Zoom, just like we would do in court, except we're just not in court at this particular time. So it seems relatively simple. There's a lot of legwork that we have to go through. You do need to know who the jurist is, so you know where the request goes in particular. But other than that, it seems like it's going to work very well. I've signed a couple of orders already and it's gone fairly well. I haven't had any objections to date. Just so you are aware, we are not just looking at this point in time whether the person has successfully completed the program, given the pandemic that we are experiencing. We are looking at, has that person performed well enough to be released given the current state? And so our standards have been changed just a little bit to make these accommodations for our youth. There will be some occasions that some youth will not be able to come home at this point in time. It will be done on a case-by-case basis, and it will be determined ultimately by the jurist of record. Once the CMO obtains that order that says that the youth can be released, and the youth, in fact, can be released, hopefully with some type of post-care services that are using some form of social distancing. So we still don't want our youth in the community having to meet with therapists or tutors or anything else like that. We want them in a place where if they're going to participate in those services, they're either doing it via some form of telecommunication and not necessarily meeting at particular locations. So that was the question that I've received the most, and that's the one thing that I did want to address. I encourage you to follow me on Facebook, to follow me on LinkedIn, and to follow me on Instagram at Judge Karen Braxton. I will again post as many updates as I can as soon as they become available to me. I do want to be able for you to have that information so it's helpful for you. And so we can figure out how to navigate these waters together. If you have any questions or concerns, I do caution people that my judicial page is always open, but I cannot have any ex parte conversations or communications with parents in this particular case, or prosecutors or CMOs or anyone else. So I try to answer any and all questions that are posed as it relates to procedure, but I cannot answer questions as it relates to an individual's case unless all parties are involved in that communication. And that's the way we do it in court. And that's the way I have to continue to do it at this point in time. So I would urge certain parents that have access to this page that you do not contact me directly, because that would be an inappropriate conversation. And again, that goes for the CMOs as well as the prosecutor's office. Our communications will always be involving all of the parties as we discuss the children in this case. As it relates to procedure, I'm always willing to share the procedure again once it becomes public from the court. I will share it with you on my social media sites so you can have that information. If you continue to have concerns about procedure whenever I post these, feel free to put any questions or concerns that you have. Again, not case specific, but if it's a general procedural question. The judges are meeting via Zoom weekly, and so we do bring up issues that have arisen as we continue this new process. And so if you put those questions there, I will be more than happy to pose that to the entire bench and to the administration and try to have an answer for you and can provide an update, maybe by YouTube, if I can continue to figure out how to use all of this new technology. So I hope that this was helpful for you today. If you have any comments, suggestions, I welcome those just as well. Again, I hope that everyone is staying safe, that you are staying home, and I hope to see you at some point in time once the court reopens. Thank you.